Would you please take your seats? We're about to begin.
John, I am shocked. I would have thought this place would be.
It's streamlined. So. Down Frank. We'll call this meeting of the Judiciary Committee to order. I'll ask the clerk to take a roll to ascertain the presence of a quorum.
Delegate Hanshaw. Present. Delegate Capito. Here. Delegate Queen. Delegate Zetezelo. Delegate Lovejoy. Delegate Lane. Delegate Canestraro. Delegate Holland. Delegate Sabonia. Delegate Deem. Delegate Pushkin. Delegate Foster. Delegate Summers. Delegate Miller. Delegate Eisner. Delegate Moore. Delegate Kessinger. Delegate Robinson. Delegate Fast. Delegate Fluharty. Delegate Overington. Delegate Byrd. Delegate Harshbarger. Delegate Fleischauer. And Mr. Chairman.
Here. Thank you, Delegate Dean. We noted your presence. A quorum is present. This meeting is being conducted pursuant to the authorization of House Resolution 201, which passed on June 26, 2018. I'm sure the first question on everybody's mind is what is the effect on our proceeding of the retirement of Justice Ketchum. I'll be addressing that when I talk about the rules in a few minutes, but essentially, as all of you on the committee know, the only remedy that's available to the House as a result of this proceeding is to recommend articles of impeachment, and the only remedy available to the Senate is removal from office. And because the retirement of Justice Ketchum effectively will result in his removal from office, we will not be spending any time dealing with the findings of any of the reports that deal with Justice Ketchum. Obviously, that may alter our schedule somewhat and probably reduce the time that we had planned on today, and maybe in the long run shorten our three-day session by some number of hours, if not by a day. So as we'll see how the evidence unfolds that we plan to present, but there is that possibility that because a block of time would have been devoted to those findings, that we will not need that time as a result of that retirement. Let me just take a moment to editorialize. I know you members of the committee have heard me editorialize before, but I think it's appropriate at this time. I know I have spent a lot of sleepless nights thinking about what we're about to undertake. I started practicing law in the fall of 1975, and during that time I also spent 18 years on a school board and was either blessed or cursed, depending on how you look at it, with being involved in a lot of significant activity. Murder trials, mergers of companies, closing schools, opening schools, the heartbreak of consolidation and closing local schools. None of that is anywhere near as significant as what we're about to undertake in this committee and perhaps in the House and the Senate. So, the ultimate result of what we're doing here today could be to overturn a duly elected officials election. Tens of thousands of West Virginians voted for our Supreme Court justices for 12-year terms and invested in them substantial trust. And on the other hand, though, when you think about it, the least accountable of our public officials is someone elected to the Supreme Court of Appeals. And that's because of the length of the term. Each of us has to face the voters every 2 years. And so we're more likely to be scrutinized during that 2-year period. So we have an obligation to also hold accountable those public officials who the voters can't hold accountable for activities that occur during such a lengthy term. I had an opportunity to do a little bit of research leading up to this about the federal system, which of course our Constitution is modeled after the federal Constitution, and the impeachment of judiciary in the federal system. As you all know, the federal judge has a lifetime appointment, so the process of impeachment plays a significant role in holding those people accountable. We've only had one U.S. Supreme Court justice attempted to be impeached or be impeached, and that was Justice Samuel Chase back in 1804. 1804. He was nominated, by the way, by President George Washington. And the result of that proceeding was an acquittal. So there's never been an impeachment that resulted in removal of a U.S. Supreme Court justice. There have been some federal judges impeached over the history of our system. According to the information I had, there have been 15 times when federal judges have been impeached. Of those, 8 were convicted, 4 were acquitted, and 3 resigned before their impeachment proceeding concluded. So this is a rare, fortunately a rare process, a rare proceeding, critically important, but also, and I hope you will appreciate that we are, in a sense, been given the power of impeachment, encroaching to some extent upon a different branch of the government. And if you value and cherish the separation of powers doctrine and the balance that it brings to our government, I think you'll appreciate the importance of what we're about to do. I know that during the course of the leading up to this, there have been a lot of folks that have analogized what we're about to do to a grand jury proceeding. I would urge you to resist the temptation to do that. I think there are fundamental differences in the grand jury process and what we're about to do here today. For instance, unlike a regular trial, a defendant cannot have any counsel present in the grand jury proceeding and may not even know what's going on. A lot of these grand jury proceedings are held in secret. There's no way to screen grand juror members of that grand jury for bias or any other thing that would affect their impartiality. There's no rules of evidence. No one there to cross-examine the witnesses that are brought forward. And in fact, the state or the federal government, in whichever case it may be, can use illegally obtained evidence as part of the case they present to the grand jury. All of that, and this, I'm sure most of you have heard this famous quote from Judge Wachtler, who was the chief judge of the Court of Appeals in New York, when he said district attorneys now have so much influence on grand juries that by and large they can get them to indict a ham sandwich. And I think to illustrate that point, the Bureau of Justice Statistics back in 2009 and 2010 analyzed over 161,000 cases that were presented to a grand jury. And of those over 161,000 cases, only 11 were cases where the grand jury did not indict. So if you're a mathematician and you did the math, you would find out that 99.99% of the time a case is presented to a grand jury, there's an indictment. And that's why I suggest to you, let's resist the impulse to consider this like a grand jury. If you were looking for an analogy, probably a preliminary hearing might be a better analogy, because in our rules, and we'll go over this shortly, we're going to allow questioning of our witnesses by those who represent the subjects of our investigation, those who represent one of our justices. I think basically we ought to consider this not either a grand jury or preliminary hearing. It's really a hybrid type of proceeding, because if you are familiar with the criminal system, or have participated, hopefully not on the defendant's side, in a criminal process, you will know that the grand jury process is in many cases intended to create leverage in favor of the state. I've had limited experience before a grand jury. 3 years of my practice were as an assistant prosecutor, and I was before 3 different grand juries, and I never had one refuse to return a true bill or an indictment. It's a pretty intimidating process if you're in the grand jury room, and it's often the case that the prosecutor wants to get as many charges as he or she can in order to have some leverage in the plea negotiations with the defendant. Preliminary hearing, the same sort of situation. It's a very low standard of probable cause. Usually it results in a finding of probable cause. And so the whole setup is designed, in many cases, to avoid a trial, because the prosecutor and the U.S. attorney have, in most cases, a great deal of leverage to negotiate with the defendant over a plea to avoid the need for a trial. And that's, I've heard people criticize that. It's actually very necessary, because if we tried every case that was a result of an arrest, our courts would be backlogged and clogged for just an innumerable period of time. So In our case, we have basically one remedy, as I mentioned earlier, and that is if we recommend articles of impeachment that are adopted by the House and we try them in the Senate, the only remedy is removal from office. There's no way to negotiate a plea. So I think that's a fundamental difference in this case between what happens in a criminal proceeding and what happens here. One of the questions that we as a committee will decide is what sort of burden we want imposed on the presentation of our evidence in order to justify our recommendation of of the adoption of articles of impeachment. I'm going to suggest to you that we ought to adopt a pretty strict standard. We have preliminary indications, it's not final, from the Senate as they are working on procedural rules, that they will likely impose a clear and convincing evidence standard, not preponderance of the evidence, but not beyond a reasonable doubt either, which is the highest standard. They will impose on us, when we come to them, if we come with articles of impeachment, that we prove it by clear and convincing evidence, and they are likely to apply the West Virginia rules of evidence. Now, we're free to do whatever we want as a committee. There's really no guidance in our Constitution as to what we need to satisfy ourselves that one of the conditions set forth in the Constitution has been satisfied, or any of the conditions to go forward. That's up to us. And so we will, by the result of these proceedings, decide what that standard is. But I suggest to you that we ought to assume that the Senate will, in fact, require the proof by clear and convincing evidence, and that we conform to the rules of evidence as we present our evidence to them. I know that there is a great deal of sentiment to apply a lesser standard, and I will readily admit that it would be cathartic to come out of the House with articles of impeachment in certain situations, just because of some of the reactions that we've had to some of the revelations about activities in that branch of the judiciary. But I would strongly suggest that, and especially for sake of those 5 managers who will have to present our case to the Senate, that we apply a strict standard to our analysis of the evidence and what we are going to require in order to make that recommendation. The end result will be whatever we can convince 23 senators of, because that's what's required, 2/3 of those elected, that falls within the conditions of the Constitution, will be what prevails. But I would suggest it would be dangerous and probably irresponsible of us to assume that they're going to be lax in the way they view our evidence. Now, I want to talk for a minute about the rules that we're going to be following during today's and the following day's process. You should have a copy of the procedural rules, giving due credit to now Judge, former Judiciary Chair John Hatcher, whose rules of procedure for the proceeding back in 1969 involving Treasurer A. James Manchin we've used as a guide, but there are some differences. Conditions change. Obviously, technology's changed in that period of time. I want to call your attention to the one rule that is certainly different than anything in Judge Hatcher's draft, and that is rule number 12, which was created basically in response to the resignation of Justice Ketchum. And I'm just going to read the rule to you, and then I'll basically talk a minute about it. Here's how the rule reads. Because the sole remedy available in an impeachment proceeding is the removal from office of an officer of the state, the resignation, retirement, or some other act which effectively results in the removal of an officer who is a subject of the proceeding from his or her office eliminates the need for further evidence specifically referring to that official. In order for the committee's time to be more effectively employed and to reduce the cost of the state, no such evidence will be admitted following receipt of notice of the resignation, retirement, or action resulting in the removal of that official. And counsel for the committee and the members of the committee will be instructed accordingly by the chair. However, evidence regarding a group of which that official is a member, if otherwise relevant for purposes of considering the allegations involving other members of that group, or for the purpose of considering the need for legislative action, shall be permitted. As you'll recall from the resolution, one of our tasks is to identify any legislation that might be needed as a result of our inquiry. So we will be addressing certain findings shortly in the legislative reports, legislative auditors' reports, that involve the court as a group. That's relevant. It's also relevant in terms of how it affects those individuals who are still on the bench or have not been removed. So I will ask for your cooperation in that, but if I see a question coming that violates the spirit of that rule, we will, I'll basically rule it out of order. So that should shorten our proceedings somewhat. As I said earlier, we had some findings that affected Justice Ketchum, and we will not be getting into those today. Now, the way we'll proceed, counsel for the committee will call a witness. We'll ask direct questions of that witness. When that testimony is concluded, we'll go around the room, and I'll probably start from my left and go down the row and ask if members have questions. And rather than hit your button, since I'm going to proceed in that method, I would just ask that if you're the next person up, indicate by raising a hand or a finger, not the middle finger, but a finger, to alert me that you want to ask a question. And then I'll call on you. That way I don't think anybody will feel like they need to ask a question if I call on you by name. If you want to ask a question or questions, as I come down the row, and I'll begin with Delegate Fast after we're finished. We'll go through the whole process, and we'll come back to counsel. No, I'm sorry. We'll go to counsel for the subjects of our investigation. We have two counsel present today that may or may not want to ask questions. In our rules, we permit that. I think it's important for the committee to know if there are issues out there that the subjects of our investigation want raised. We've provided in there for a method by which they can request witnesses that we call, but also that they can ask questions. When that process is finished, we'll go back to our House counsel to see if any follow-up questions are needed. We'll make a second rotation through the chamber of our members to see if you have follow-up questions that may be needed. Please don't feel like you have to ask questions, but if you do, please feel free to ask questions. And when that process is concluded, and that will include those of us up here at the podium, Delegate Flashauer, Delegate Hanshaw, and me will also be free to ask questions, but we'll be the last of our committee members to go. So that's basically how we'll proceed. The sequence of our presentation, as I outlined in emails that I sent out, will be by subject matter. The subject of, for instance, vehicle use will be the first subject matter that we'll get into. It may or may not involve more than one justice, but if it does, we'll cover all of the involvement of each justice at the same time. Purpose of that, for efficiency and also as convenience to our witnesses, well, we don't treat them like a yo-yo and have them back here every other day or every other hour to answer questions. We'll try to deal with that in a more efficient way, and it also, I hope, will provide some context for you, overall context within which to judge this witness. I should say that we're going with the legislative auditor's report first because that was the first information that was made available to us. We had to subpoena the information from the Judicial Investigation Commission based on their process and their confidentiality. It's taken a while to get that evidence, and it's basically come in this week in batches on thumb drives. And I think we've gotten 2 so far, is that right? Just 1 yesterday. And we're not talking about 5 or 6 pages. We're talking about, in some cases, hundreds if not thousands of pages. So it's taken our staff a good bit of time to go through that, get it organized, and basically focus it on the information that we need to make a decision. You are being provided with some documents this morning. The packet of documents consists of 18 exhibits that council intends to discuss with our witnesses today. As I said, the auditor's office, as well as what I'll refer to as JIC, has provided us with numerous documents, and staff has been reviewing those documents. Some of those documents are as long as 1,000 pages. Believe it or not, some of the documents, though, contain personal information that is either confidential or irrelevant to these proceedings. That's why they focused on these 18 exhibits. The documents that you are being provided are mentioned in some of the reports that will be discussed today. We have encountered one problem in preparing for this proceeding, and that is getting a court reporter. Council has tried 3 or 4 firms. The problem is no one's willing to commit to the number of days that we need someone here. So we are recording this in 2 different ways. It's video stream, so there'll be a recording of that, and there'll also be an audio recording. And ultimately, if we need transcripts, we will provide the audio recordings to stenographers to actually prepare the transcript. I will say that all of our sessions are going to be open, and therefore they will be video and audio streamed. They'll be open to the public. You can see we packed the house today. So obviously we'd expect you to act appropriately. The only exception that I can see that might happen, and this will be a committee decision, not a decision of the chair, is when we're finished with the evidence and we need to discuss how the evidence may or may not fit in with the conditions that the Constitution requires for us to, the categories maybe is a better way to put it. We may go into executive session so that we can have an open and uninhibited, let's say uninhibited discussion about that. That's the only time I think there will be any possibility of an executive session, and that will be based on your decision as a committee. Those conditions, for the benefit of our press and the audience that may or may not be listening, is that the Supreme Court requires findings of either maladministration, corruption, neglect of duty, incompetency, gross immorality, or high crimes and misdemeanors. And unfortunately, none of those are defined in the Constitution. So essentially, the definition will be what we conclude, and that may need some discussion. As you'll recall, there's some cases cited by Judge Hatcher in his memorandum, but none of those cases are West Virginia cases. So we are in many ways plowing new ground by what we do, and I would encourage us to keep in mind not just this proceeding, but any proceedings that the state might unfortunately have to go through in the future as to what kind of standards, what kind of bar we set for that type of inquiry. For logistical purposes, we'll take a lunch break today. It just depends on the flow of the evidence, but I expect it'll be somewhere between 12 and noon. We'll resume and we'll take a dinner break. I'd hope to get some time in this evening, which, based on the retirement of Justice Ketchum, may result in us, if we work tonight, not having much of a day, if any, on Saturday. So we'll be bringing dinner in, and it will be served upstairs in our committee room. So we'll take a break probably between 5:30 and 6 for that purpose, and I think you'll find the meal appropriate. I suggested to my wife that because I wanted alert members after dinner that she only make 1 cake, and you'll soon find who won that argument. So my last request really to you is to help us, your managers, by putting yourself in the place of the senator who may hear this evidence. Be alert for any gaps that you might hear in the evidence that we need to follow up on, identifying any witnesses you think we need to call. Certainly our staff is amenable to your suggestions as to who we need to call, or documents that we need to fill those gaps. I suggest you ought to be willing to test the sufficiency of the evidence through your questioning. Consider possible explanations for the evidence that you hear. I think it's reasonable to consider the context within which it occurred, the motive of the person involved, whether it's for personal gain or whether there's some more worthy motive, whether it's a technical or a substantive violation, the frequency of it, whether it's isolated or frequent, and the degree of it as well. At the end of the day, when we're finished, there's several results that could, recommendations we could make. Not to impeach, to impeach, censure. I think if you read the call for the meeting, for the extraordinary session, there was the word censure in there, which we're going to try to develop exactly what that means, but the way I interpret it is basically we would recommend to the House a reprimand, but not an impeachment. We would go on record as reprimanding certain conduct of certain individuals. We may also decide that just the shedding of light, the publicity of what we're hearing today is a sufficient deterrent for that type of activity in the future, or perhaps even ammunition for the constitutional amendment that was overwhelmingly approved by the House. I'd also urge you to resist the sense of urgency that some have tried to instill in this proceeding. Obviously, the court does not meet again until September, and unlike the A. James Manchin impeachment back in 1989, the credit of the state is not on the line. If you'll recall, the allegations were that through mismanagement and otherwise, the state had lost, the Consolidated Investment Fund had lost between $250 million and $300 million, perhaps more. But more importantly, at some point, the entire portfolio of the Consolidated Investment Fund was at risk. And the credit rating bureaus were waiting for action fairly quickly. So we don't have the same urgency, but obviously the importance to the state, we need to keep that in mind. As I mentioned earlier, the balance of power between the separation of powers should impose upon us the seriousness of this. And of course, the reputation of the state we need to keep in mind. Finally, I just want to recognize before we begin the hard work of our staff, our legal staff, plus we had some volunteers, Marcia Kaufman, Brian Casto, and John Hardison of our staff, and their efforts were supplemented by Charlie Roskovinsky, Robert Akers, and Joe Altiser, and then our clerk, Mark White, and our executive assistant, Adair Burgess, also have been working really hard to try to get this together for you. Our managers have participated as well, and those include Delegates Holland, Miller, Andrew Byrd, and Roger Hanshaw. So certainly, I know there's been some perception nothing's been happening, but I can assure you that's not the case. So we're ready to proceed. Counsel, would you call your first witness? Delegate Flashour.
Thank you, Mr. Chairman. Mr. Chairman, are we going to adopt the rules prior to proceeding with the witnesses?
If you reviewed the resolution, which I'm sure you did, the resolution authorizes the chairman to establish the rules, and that's what's happened.
Okay. I have a couple of questions I'd like to ask about the rules, if I may.
If you have a point of order, I'd be happy to address it. Yes.
Well, I want to, I'm not sure if I would put it in terms of a point of order. I want to explore what the thinking was for departing from the rules of Judge Hatcher and substituting some additional sentences. And if I could inquire about that, I think, I don't know that it's in the form of a point of order, but I'd like to inquire about them.
Well, as I indicated, and this is about all further explanation I'm going to make, I took Judge Hatcher's rules, I looked at them, I tried to fit them into the context we're working with, I made some adjustments, and of course Judge Hatcher's rules are not binding on us, they're simply an illustration of one set of rules that were adopted. As I read the resolution, the chairman's responsibility is to establish the rules of procedures, and I did that so that we wouldn't spend a lot of time debating the rules. I know a lot of folks have imposed a real sense of urgency on this. I don't think we need to spend any time debating the rules or explaining the rules. The rules are the rules, and if I remember right, 89 people were here on the day the resolution was passed. Everybody voted in favor of that resolution.
Well, I guess I can turn it into a point of order. I do think the rules are an improvement in many ways over Judge Hatcher's rule. I like the fact that there's more modern language. It flows much better, so I want to congratulate you and your staff on that. My biggest concern is the last sentence that was added to rule number 8. And I believe that could potentially be a violation of the House rules. That says that no motion to issue articles of impeachment shall be considered until counsel for the committee has informed the chair of the presentation of all evidence regarding the subject against whom the proposed articles are addressed has been completed. I don't think there's anything in the House rules that gives staff that authority over the body, over the membership, and maybe just as importantly, I think that this is a rule that is not contained in the House rules and is inconsistent with the House rules that spell out the motions that members are allowed to make. So I think it is potentially a violation of the House rules, and I think that is a problem, and I would urge that be stricken.
Well, it's going to remain in there. I'll take your suggestion under advisement and confer with the clerk as well as our parliamentarian, and we'll see where we go from there. But at the moment, that's the rule. Okay, let me just make it clear for the record. Our House rules say that all rules of the committee must be consistent with the House rules generally. And secondly, the House rules allow members to make specific motions, including the one that is referenced in number 8. And by taking that authority away from members, we are departing from the rules of the House. I understand your position, and we will take it under advisement. I had two, I guess that's, I was wondering why you omitted number 16, which is in the 1989 rules. I don't really feel strongly about it. You explained why you added number 12, but also number 14, the new sentence in number 14. Well, let's proceed this way. Rather than delay the whole committee, I'll be happy to talk to you during the break as to why I did certain things, but for the time being, those are the rules that have been established pursuant to the authority of the resolution. Those are the rules we'll operate under until further notice. Okay. Thank you, Mr. Chairman. Delegate Robinson. Point of order?
Mr. Chairman, I move to amend the rules proposed by the chairman.
I want to call that out of order. The resolution, which I believe you voted for, Delegate Robinson, authorizes the chair to promulgate or establish the rules. That's what I did based on the confidence that resolution reflected. Your motion's out of order.
Point of order, Mr. Chairman.
Yes.
As we have proposed and brought in the rules from 30 years ago, in the case that 30 years from now they do the same, do you not think we should address the rules and try to amend them and make them the best possible? As we've discussed that we took a 3-week break to make this process correct as it's historical, do you not think it's appropriate for us to discuss and go through the rules thoroughly?
I don't think we need to delay the process. If you're suggesting we spend a couple of weeks debating the rules, I suggest that that's not a good use of our time.
Mr. Chairman, I have 3 one-sentence amendments to your proposed rules that are just corrections and improvements to the rules that I would like to propose if you would allow. And to the gentleman, consistent with my discussion with Delegate Flashshire, I'll be happy to discuss those with you during a break. But for now, we're going to protect the integrity of the time that we have available and move forward. Mr. Chairman, I have a point of inquiry prior to starting the witnesses.
Yeah, I'll listen to your point of inquiry.
Mr. Chairman, it's come to our attention that you may have had a meeting with the private attorney of Justice Lawford yesterday. Just for transparency, could you give us a summary of who was in that meeting and what those meetings entailed?
I did not meet with the attorney for Justice Lawfrey, nor did I meet with Justice Ketchum. I haven't met with any of the justices or any of their attorneys. My understanding is that the attorney for Justice Lawfrey visited with staff counsel to discuss the rules and the proceedings that we'll follow, but I was not a participant in any of those meetings.
At the same request, sir, for staff counsel to give us a summary and just for transparency to explain to us what went on in that meeting and what was discussed.
I don't think that's in order. If staff counsel wants to address that at a later time, we'll go forward. To my knowledge, it basically was a discussion about the rules and the opportunity to question witnesses. And that's, counsel, am I basically correct on that? Yeah, okay. Any further inquiries? Counsel, will you call your first witness? One of the reasons we've asked everybody to move forward was to the front two rows was to try to improve the ability to hear. But for the technology you mentioned, I'm not familiar with, but I'll ask the clerk's office. Is there? We'll try to get that fixed for you. Okay. Yes, sir. Counsel?
Thank you, Mr. Chairman. The House Committee on the Judiciary calls as its first witness Justin Robinson.
Would you remain standing for a moment, please?
Yes, sir.
Would you identify yourself for the committee?
Yeah, my name is Justin Robinson, Acting Director of the Legislative Post-Audit Division.
Mr. Robinson, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you shall give in the matter now before this committee shall be the truth?
Yes, sir.
Thank you. Counsel?
Thank you. Mr. Robinson, I think you have just stated your full name for the record and indicated your current position. Can you please tell again the committee where you work and what your position is?
Yes, I work for the Legislative Post-Audit Division, and I'm the Acting Director.
As the Acting Director, how long have you held that position?
Very shortly.
Was that a recent
Yes, it was.
event? Prior to that, what position did you hold?
I was Audit Manager.
Were you Audit Manager during this calendar year, 2018?
Yes.
As Audit Manager, what were some of your duties?
To assist in the planning and supervising of the audits conducted by our staff, including the Supreme Court audit.
Could you please give the committee some indication or idea as to your educational background, please?
Yes, I hold a bachelor's degree in business administration with a focus in accounting and a master's in business administration.
Thank you. Mr. Robinson, you just mentioned some post-audit reports that were completed with respect to the West Virginia Supreme Court of Appeals, and I want to begin with that and ask just a few general questions. Okay. It is my understanding that 3 reports were completed during this calendar year so far. Is that correct?
That is correct.
For ease of reference, if it is okay with you, I will, during my questioning, be referring to those reports by number. Again, if that is okay, report number 1, report number 2, and report number 3. Is that okay with you?
That will be fine, yes.
With respect to those reports, do you recall, and I'm not asking for a specific date, but do you recall the months or the time period in which those reports, beginning with report number 1, were completed?
Yes, the first report was completed and presented to our post-audit subcommittee in April, the second report in May, and the third in June. Okay,
and that was all of this year, 2018?
Yes, correct.
Okay. With respect to the 3 audits, did your office and all of the individuals that worked on these reports, did they follow or conform to any type of specific standard when it comes to auditing?
Yes, our office follows the United States Government Accountability Office's generally accepted auditing standards.
And were those followed with respect to all 3 of these reports?
Yes.
I would like to, if it's okay with you, go ahead and just move to report number 1.
That'd be fine.
It is my understanding from this report that at least one of the issues that this report addresses is the use of state vehicles and rental cars by members or justices of the West Virginia Supreme Court of Appeals. Is that correct?
That is correct.
Did your investigation look at all of the current justices of the Supreme Court of Appeals?
The first report covered a couple justices, and the second subsequent report covered the remaining current justices as well as one former justice.
Which former justice was?
Justice Brent Benjamin.
Okay. With respect to, and I'm going to try to the best of my ability to remain on report number 1. With respect to that report, I believe that it indicates that on page 1 of that report that the initial focus, and I'm just going to ask you about this initial focus, concerned that use. Could you please just tell us what precipitated that particular focus in this audit?
Are you asking how this audit was incepted?
Yes.
Essentially, concerns were expressed, obviously, in the media concerning extravagant expenditures by the court regarding renovations, as well as the fact that in previous reports conducted by the Performance Evaluation and Research Division of the Legislative Auditor's Office, as well as the Post-Audit Division, was having a focus on state vehicle fleets.
Okay, thank you. By way of background, I want to just make sure when I begin asking these questions that my assumption here is correct. It's my understanding that the justices of the Supreme Court have or had or have exclusive use to 3 different vehicles. Is that correct?
That is correct.
Okay. I'm going to ask you now with respect, and it's my understanding that you are and do have in front of you a copy of the report number 1. Is that correct?
I do, that's correct.
Okay. I will ask you if you could please to skip over, we will skip over the first few pages of that report and move to page 7 of that report.
Okay.
At the time that this particular report was finalized, if you know, did the Supreme Court have formal written policies regarding vehicle use?
Specifically to your question, at the time the report was finalized, I believe the court was actually formulating those policies, but at the time when we inquired whether or not the court had those policies while we were conducting the field work of the audit, they did not have those policies in place.
With respect, and going down and still remaining on page 7, there is a mention about an internal reservation system that is described essentially as a calendar. Mm-hmm. If I can, I would just like for you to try to the best of your ability to explain to the committee what is meant by that, by the internal reservation system.
The only record the court had to indicate when vehicles were used by employees or justices was a reservation log that was maintained internally electronically, to which if a employee or justice needed to use a court vehicle, they would request its use through this reservation log.
And I believe that the chairman mentioned this before. With respect to the reservation log, is that in and of itself a very large document?
Yeah, it's in excess of 1,200 pages.
Okay, just for that one document?
Yes.
Okay. And was your office provided with a copy of that reservation system?
Yes, we were.
That's how you know it's over 1,200 pages?
Absolutely.
During the time period that your office looked at this particular court reservation system, and I'm going to ask you to confine, and I'll try to my best of my ability to confine my questions to Justice Lawfrey only, and I understand we're on page 7 and that's what this deals with. Could you please tell the committee how many days Justice Lawfrey reserved a car during that time period of your investigation?
Based on the vehicle reservation log, we noted 212 instances where Justice Lawfrey had reserved a vehicle.
And with respect to those 212 days, can you please tell the committee how many of those times he did not list a destination?
Justice Lawfrey did not list a destination for 148 out of the 212 days that he reserved a vehicle in the vehicle log.
I believe that as part of your investigation that you put that in to a percentage, and that was roughly 70% of the time. Is that correct?
That's correct.
On page 7, table 1, could you please just, it seems pretty self-explanatory, but just out of an abundance of caution, could you please let the committee know what table 1 represents?
Yes, table 1 is a summation of our review of that vehicle reservation log for the years 2013 through 2016, and for each year it notes the total days of vehicle use noted in the reservation log, the number of days for each of those years that did not provide a business purpose substantiation, and the percentage of usage without substantiation as it represents the two figures.
I'll now ask you to move to page 7 of that report. There is figure 2 on that, and I would like to ask you the same question. If you could please just generally describe to the committee what figure 2 represents.
Figure 2 is our attempt to represent this information more visually through a calendar. We essentially laid out a yearly calendar for the years that we reviewed, specifically through 2015, because beginning in 2016, the notations of Lawfrey's use of the court vehicle was sparse. So this calendar essentially represents the dates that we noted where he had reserved a court vehicle in that vehicle reservation log. There are blue highlighted dates where he did provide a destination. There are red highlighted dates where he did not provide a reservation or a purpose, and the court was also in recess. And there is it's more of an orange color highlight for indicating when dates did not provide a destination.
And that orange highlighted color, is that when the court was in session?
Yes.
I'm now, just so that everyone can remain on the same page, I'll now like to move to page 9 of that report. At the top part of that page, there is a pattern that is noted as a result of your investigation. Could you please inform the committee of the pattern that is noted as you completed and went through your investigation?
Yes, as we review these vehicle reservations with particular regard to dates when the court was in recess, we noted 3 years consecutively where Justice Lawfrey had reserved a court vehicle over the Christmas holiday and in certain instances well into the new year.
Remaining on page 9, there is mention underneath figure 3 of a memo that was written by the Deputy Director, the Director and the Deputy Director of the Supreme Court. And with that said, I would ask that you please refer to Exhibit number 1, the document that has been pre-marked as Exhibit number 1.
Yes.
If you could, and I recognize that you did not author this document, but could you please just explain to the committee how you came into possession of this document and generally what it purports to be?
Yes, during our process of gathering information and evidence, we requested any and all internal court memorandum that discussed the use of court vehicles, and we were provided this memo. This particular memo, Exhibit 1, is in reference to a memo from the Deputy Director and Director of Court Security to Justice Davis regarding some questions she had about the formal checkout procedures for court vehicles.
And this, I believe, is noted in your report on page 9, and it is in the memo. Could you please read the last sentence of Exhibit number 1?
Yes, the last sentence reads, "The only person we can recall that failed to provide a destination when asked was Justice Lawfrey."
Okay. Remaining on page 9, there is also mention of other memos that went back and forth, and I believe you just indicated that you had requested those memos.
Yes.
I would ask for you to please now refer to Exhibit number 2, and if you could please, as you just did, try to explain to the committee how you came into possession of this and what this is.
Again, this was in relation to our request for any internal memorandums of the court discussing court vehicle use, specific with regard to justices using those vehicles. This particular memo is from Justice Davis to then Administrative Director of the Court, Steve Canterbury, requesting that a few items be placed on their administrative conference agenda to discuss procedures concerning the use of court vehicles and other questions that she had regarding this use by the justices.
And now I would ask for you to move to Exhibit number 3. This also appears to be a memorandum.
Yes.
Could you please tell the committee what this memorandum is about?
This memo is from Justice Davis to the Deputy Director and Director of Supreme Court Security. Give me 1 second to review it. Justice Davis is requesting from the director and deputy director of court security who were actually in charge of overseeing that vehicle reservation log to provide her the answers to the 3 questions in this memo, essentially regarding the procedures for reserving those vehicles and their use.
And now, if you could please refer to exhibit number 4. Is this another memorandum that you received during your investigation?
Yes.
Is this memorandum also dealing with the use of state vehicles?
It is.
At least in part, it appears. And I would also ask now that you refer, please, to exhibit number 5. Is this also a memorandum?
It is.
Is this another memorandum from Justice Davis?
Yes.
And who did she send this one to?
This was going to former administrative director of the court, Steve Canterbury.
Okay. And was she still requesting additional information at that time?
Yes, it appears in this memo she was actually requesting specific information regarding Justice Lawfrey's use of a court vehicle to which she believed he did not provide business use.
Okay. I'm going to jump back to your report now and still remain on page 9. I believe the next to last sentence on that indicated that Justice Lawfrey had made some type of response to this, to the memos that had been sent questioning the usage of his usage of state vehicles. Is that correct?
That is correct.
I would now like for you to please refer to exhibit number 6. Is exhibit number 6 the memo that is referenced in which Justice Lawfrey responded to the memos from other court members about usage of state vehicles?
Yes, I believe so.
Okay. And I understand, again, you didn't author any of these. If you could, either from your recollection or review of the report, what was Justice Lawfrey's response?
His position, as stated in the report, was that once he stated to court security or any other individual questioning his use of the vehicle that the purpose was for state business, that should be the end of the inquiry.
Okay. Mr. Robinson, I'm now going to ask you to remain on your report, but to move to the next page, again, still dealing with Justice Lawfrey. And on page 10 of this, it begins by noting that the legislative auditor questions Justice Lawfrey's need and use of state-paid rental vehicles during out-of-state trips. So just so that the record and the committee members are clear, does the report now move to the focus now is on rental vehicles as opposed to the state vehicles?
Yes, this portion of the report focuses on rental car usage by Justice Lawfrey.
Okay, just by Justice Lawfrey in this particular area?
Yes.
Okay. If you could please just summarize for the committee the findings, the legislative auditor's findings with respect to Justice Lawfrey's use of rental vehicles.
We noted on several occasions that Justice Lawfrey had utilized a rental vehicle for out-of-state trips relating to court business, for which he put substantial amounts of miles on those rental vehicles during those trips. Also, in many of those instances, Justice Lawfrey took the fuel option of the rental, meaning that when he returned the car without fuel, the rental car company would refill it for a charge. There was also other fees we noted, including upgrade fees and other indirect costs associated with this rental car use, such as hotel parking for the vehicle, which in certain instances was somewhat substantial. And essentially, we just note in this section of the report those particular instances we noted that had substantial amounts of rental car mileage use.
On table 2, on page 10 of report number 1, There is a listing of, I believe, 7 different instances of rental car use by Justice Lawfrey. Is that correct?
That is correct.
Are those the 7 instances that you focused on? Were there others, or are these the ones that were noted when there was additional mileage put on the cars, if you recall?
I can't recall if there were other instances that we looked into, but these are the particular instances we noted with excessive what appeared to be personal use mileage.
And when you say noted that appeared to be excessive personal use mileage, if you could just explain for the committee how you came to that that assumption, given the mileage that is listed on this table.
The information that we used to derive the calculation of the number of miles essentially was the location of the trip, the airport to which he flew to, the hotel to which he took from the airport to the hotel that the conference was often held at or he was staying at. And essentially we calculated the difference between the mileage from the hotel to the airport, and then we compared that with the total number of miles actually driven on the rental car receipts. So essentially we use rental car receipts, hotel receipts, travel expense settlements provided by Justice Lawfrey to the court to be reimbursed for expenses, amongst other documentation.
With respect to these 7 instances that are identified in table number 2, and I don't want to get too far ahead of myself, the travel, and I won't read them all, but they are to California, Omaha, Nebraska, to Monterey, California. Was it determined that those trips, the trip itself was for a business purpose?
Yes, oftentimes it was for a conference related to justices across the United States or some other court-related business purpose, yes.
Okay, so it wasn't found that it was solely for a personal use. The reason for going was oftentimes, I think you said, for a conference. Is that correct?
Yes, for each of the instances noted, the actual purpose for the trip was court-related business, yes.
But then what, again, I think you have noted, and I want to make sure I understand, is that in addition to going to the conference, it is believed that the rental car was used times anywhere between several hundred miles to go elsewhere. Would that be correct?
That is correct. What we noted were essentially that the round-trip distance from the airports to the hotels were oftentimes, and I think the highest mileage between those was 27 miles listed in our report. But in those instances, the difference in miles actually used on the rental car were in excess of 400 miles, which indicated there was significant travel outside of just to and from the airport.
Now I have a question with respect to the calculations that are in that last column on table 2, the total cost. When we're talking, and I know you said you looked at the fuel option that was oftentimes selected and parking and things such as that, did any of that account for mileage? And the reason I ask that is with respect to rental cars, it's my understanding that a lot of times, if not a lot of times, there is an unlimited mileage option. Were there any charges associated with those actual miles that were driven, or do the amounts in that last column deal with other things?
The amounts in the last column actually is a summation of all the costs associated with the rental car use. There was no particular additional charge associated with the mileage put on the cars. Oftentimes rental car vehicles do have unlimited mileage, but for us, the significant number of miles indicated the potential that the purpose for renting the vehicle was personal in nature and not simply for transportation to the event that he was intending for court business.
Okay. Mr. Robinson, I'm now going to ask that you move to page 11 of that report. And I believe you have just gone over this, the first full paragraph beginning with "in addition" on page 11. Does that identify the other expenses that were used in part of the calculation as to the amount you came up with, the total of $2,668.64?
Yes, that paragraph does describe the additional charges. I wouldn't say that it's a comprehensive list, but it does summarize the key costs associated with this rental car use.
And that is that amount, and I know it's been rounded up on page 11, it's just right around $2,669. Was that an amount that the legislative auditor requested be reimbursed by Justice Lawfrey?
No, we did not directly request or indicate to any justice concerning any of our reports of the fact that they should reimburse. We did inquire of Justice Lawfrey had he made any reimbursements concerning any personal vehicle use or anything else related to our reports, to which he did not respond.
Okay. Now, if we could, and this is with respect to, still on page 11, these are a little bit different issues, but I think still dealing with Justice Lawfrey with respect to the travel regulations that were filed, granting the justices different treatment. If you could please just generally explain to the committee this particular finding about these travel regulations.
Yes, essentially we, looked into the travel regulations on file with the West Virginia State Auditor's Office, which is required for them to perform travel reimbursements when requested and make the payment to those requesting the reimbursement. When we reviewed these regulations, we noted in particular that regarding the use of rental cars by justices, it seemed that there was special permissions granted to them regarding the reimbursements they were eligible for regarding the rental car use.
Did that regulation, as your investigation went further, would the use of that and asking the reimbursement for the entire thing, even if there had been personal use, would that have been a violation of the actual travel regulation filed with the auditor's office, or no?
I'm not sure of that.
Okay. Now, if you could please move to page 12. There is a finding or a notation at the top of that page about taxable fringe benefits use of state vehicles. If you could just now take a little step back and explain to the committee what we're talking about and what you mean when we start down this path of the taxable fringe benefits.
A taxable fringe benefit is anything provided to an employee when you allow the employee to, it's similar to allowing an employee to commute to work in a vehicle. It's any benefit provided to the employer that has a value that they are not responsible for incurring a cost of themselves.
And I believe the finding on page 11 indicates that the Supreme Court did not report, I'm sorry, page 12, I've indicated the wrong number. The Supreme Court did not report the taxable fringe benefit of Justice Lawfrey's use of state vehicles on his W-2s as required by federal tax law. Was that the finding of the legislative auditor?
That was the finding, yes.
Okay. And was this one of the recommendations, or how was this just a finding in the report? Did anything come of this, if you know, with respect to Justice Lawfrey's W-2s?
I am unaware that Justice Lawfrey had been issued any amended W-2s. I believe the only justice that was issued an amended W-2 concerning any use of state vehicles identified by our reports was Justice Ketchum.
Okay, but you're unaware of any issued to Justice Lawfrey?
That's correct.
There is a notation about a March 28, 2018 letter that was sent by the legislative auditor to Justice Lawfrey. I think you just previously noted that. Is that the one that you were talking about earlier, a letter sent asking about the reimbursements?
Yes, it is. We essentially sent Justice Lawfrey a request to inform us of any reimbursements he had made to the state concerning any personal use of state property.
Okay. And I believe it's also noted on page 12, and it is attached, I believe, as Appendix G to this report. Maybe I apologize. On page 52, Justice Lawfrey did send a response by letter. Is that correct?
He did not send a response directly to our office. He sent his response to the now former director of court administration, Gary Johnson. Okay.
And I believe if you could please refer to page 52 of report number 1, just so that we're all clear. I want to make sure that is the letter to which you referred.
That is correct.
Okay. And if you could please just read the first paragraph of that letter to the committee.
Paragraph reads, I have reviewed the revised draft audit report dated April 10th, 2018 from the Legislative Auditor's Office. I have also reviewed the proposed response of our court, which has been agreed to by all 5 justices. The draft audit report refers to me in at least 2 of the 4 designated issues. I disagree with the factual and legal assumptions made, the standards and definitions applied, and the conclusions ultimately reached in the draft audit report.
Okay, thank you. Mr. Robinson, I am now going to ask, as we remain and stay on the topic of the use of state vehicles, I am now going to ask that you please refer to report number 2. And specifically page 2 of report number 2. It is my understanding from the issue identified on page 2 that this addresses Justice Davis's use of the state vehicle. Is that correct?
That is correct.
With respect to the investigation, did you look at Justice Davis's use of the state vehicles as well?
Yes, we did.
How many reservations did you find that Justice Davis had made during that time period that you did your review?
Our initial review of the reservation log indicated 75 vehicle reservations.
And I believe that it's noted on page 2, I want to just confirm that you looked at those reservations from 2011 through 2018, is that correct?
That is correct.
Of those 75 instances, were there some instances in which Justice Davis did provide destination information?
Yes, there were. I believe the report notes, and let me clarify this. I believe 55 of the 75 reservations, there was determined a business purpose and destination.
Okay. And with respect, so that leads me to my next question. So it appears from that there might have been some instances in which there was not a destination identified. Is that correct?
That is correct.
And did you reach out to Justice Davis to request information, any additional information that the Justice may have about those travel events?
Yes, we did. It was indicated to us that as the reservation log was a reservation system, just because the vehicle was reserved did not always indicate that it was used, and we used other methods to confirm whether or not that was the case.
And in that regard, if you could please now, with respect to the exhibits, please refer to exhibit number 7. If you could, again, I continue to state this just to be clear, you did not author this exhibit, but if you could please just identify this for the committee and tell them what this is generally.
Yes, this is the response provided by Justice Davis's attorney concerning a request for information concerning those dates. We identified that she had reserved a court vehicle, but we could not substantiate a business purpose or destination.
And I believe there is at least one exhibit attached to this letter that goes through those, some of the instances, the dates that were in question. Is that correct?
Yes.
Okay. There is a notation on page 2 of report number 2 that Justice Davis indicated that she traveled in court vehicles only when she was accompanied by the Director of Court Security. Is that your understanding?
That is correct.
And if you know, for what reason did court security travel with Justice Davis in the state vehicles?
I believe Justice Davis had some personal security concerns to which she provided, or Arthur Angus provided her security on business-related trips associated with the court.
Okay. There is a notation, and now I will ask you to go to page 3 of report number 2. Underneath Table 1, there is a paragraph about some vehicle use by Justice Davis, and that would be in the November 2011 timeframe. Could you please describe what you found with respect to that travel in November of 2011?
Yes, essentially from the dates of November 13th through 15th of 2011, Justice Davis reserved a court vehicle and traveled with Arthur Angus, the Director of Court Security, to some truancy events, I believe in Parkersburg and Wheeling. Coincidentally, after attending the first event, she traveled to Parkersburg and attended a political fundraiser that evening. Did not charge any lodging to the state, and then on the next day she attended the second anti-truancy meeting in Parkersburg. So I believe her first trip was to Wheeling, then she traveled to Parkersburg the subsequent day, and then returned to Charleston.
Mr. Robinson, if you could please now, I will move to page 4 of report number 2. I have just a few questions. I believe you have indicated this. I just want to make sure that the record is clear. Who is Mr. Steve Canterbury?
He's the former administrative director for the Supreme Court of Appeals of West Virginia.
Okay. With respect to Mr. Canterbury, was his car usage also reviewed?
Yes, we actually reviewed the
Please report your order. Mr. Chairman, Mr. Canterbury is Mr. Canterbury a subject of impeachment today?
Not by this committee. We're providing context. I'll ask counsel to continue.
With respect to Mr. Canterbury, the investigation into Mr. Canterbury, I apologize, I can't recall if I just asked this, what both the vehicle use of state vehicles and rental cars reviewed?
Yes, they were. For all sitting justices at the time these reports were issued, including the former Justice Brent Benjamin, the current administrative director at the time, Gary Johnson, and former administrative director, Steve Canterbury, we consistently reviewed this vehicle use in the same manner for each.
For Mr. Johnson and Mr. Canterbury?
Yes.
Okay. And again, just a few questions with respect to Mr. Canterbury. I believe this is noted on page 4. With respect to the time period that you looked at, how many times were you able to determine that Mr. Canterbury used a state vehicle?
Based on their reservation log, 78 times.
Okay. And with respect to the destination or the purpose for the trips that Mr. Canterbury, or the reservations rather, Mr. Canterbury made, did he provide a purpose for each of those 78 trips?
No, the report indicates that Mr. Canterbury did not complete the purpose section of the reservation log for 36 of the 78 uses.
Okay. I don't want to assume anything. Did you have an opportunity as part of this investigation to speak with Mr. Canterbury about this?
We did.
And if I could, I would just ask for you to please refer to exhibit number 8. Is this a list of the 78 times that Mr. Canterbury, just in a format that Mr. Canterbury used the state car?
Yes.
I would now ask for you to please look at exhibit 9. I believe you just indicated that you did at least meet with or have spoken with Mr. Canterbury. Could you please just tell the committee what exhibit 9 is?
We inquired of Mr. Canterbury to provide us further explanation for the dates that he did not provide a business purpose or destination, to which he looked at his personal calendars to indicate if he had record of travel for those dates. In instances where he did have record of travel and the purpose, he provided those to us in this exhibit 9.
Okay. And so in exhibit 9, he took the time to go back and look at his records and try to come up with where these trips might have been to. Is that fair to say?
Yes, absolutely. I believe also we tried to obtain the personal calendars from the Supreme Court of Appeals that would have indicated possibly those dates, but when we requested them, we were informed they were missing.
If you could please refer to exhibit number 10. You were one step ahead of me. Could you please tell the committee what exhibit number 10 is?
Yes, exhibit 10 is a memo from the executive assistant to the administrative director to the then current administrative director, Gary Johnson. Essentially, this memo indicates that she was asked to provide the daily calendars maintained by the court for the current and former administrative directors, and as she indicates in this memo, they were missing.
Okay, they were missing.
Yes.
Okay, and lastly, with respect to this, if you could please just generally inform the committee of the of Table 2 on page 5 of report number 2. Again, if you could just generally indicate to the committee what information is contained in this table.
Table 10 is a summation of the rental car use by the former administrative director, Steve Canterbury.
And I note at the bottom there's a finding, or an amount rather, let's say, of $911.04. What's that?
I think that in the total column for the total cost, including which is the second to last column, indicates the amount of $11,076. This was the total cost of his rental car uses. The last column indicates amounts improperly reimbursed to Mr. Canterbury. He was actually, in many of these instances, he paid for these rental cars up front and requested reimbursement, and it notes the amounts of improper reimbursements for various reasons.
Okay. And if you could now please refer to exhibit number 11, and if you could just tell the committee what this is and what Mr. Canterbury did after meeting with you or speaking with you about this.
Essentially, after meeting with Mr. Canterbury, we discussed the amounts he was improperly reimbursed, to which he made a similar effort to Justice Ketchum to reimburse the state for this amount. Particularly the first page of Exhibit 11 is a handwritten note to me concerning this meeting, and indicating that he is also sending a copy of the letter that is subsequent to this page to the current director, Gary Johnson, along with a copy of the check. I guess he actually submitted the check to them, made out to the state of West Virginia for that amount. Okay,
thank you. Mr. Robinson, I'm now going to ask you to please skip over to page 7 of report number 2. There is a notation on that about the remaining justices and administrative directors' vehicle use. I believe you have already indicated that you, in addition to Mr. Canterbury, you also did look at the former administrative director, Gary Johnson. If you could please just tell the court the findings with respect to former administrative director Johnson.
In regard to former administrative director Gary Johnson, we reviewed all reservations. There were only 4 noted in the vehicle reservation log, and we found no issues with those. Each was for a business purpose.
Okay. Now I want to ask you about about 2 current justices. That would be Justice Walker and Justice Workman. Let's begin with Justice Walker. If you could please let the committee know what your investigation revealed with respect to the state vehicle usage or rental car usage for Justice Walker.
We reviewed both types of usage, and the only thing noted was that there was only 1 court vehicle reservation by Justice Walker, and in regard to that, there were no issues found.
Now I'd like to ask the same question with respect to Chief Justice Workman. What did your investigation reveal with respect to Chief Justice Workman's vehicle usage?
We noted 7 court vehicle reservations in the reservation log, and to which we found no issues with any of them.
Okay. The recommendation, if you could please just read your recommendation on that's located at the bottom of page 7 of report number 2, please.
Okay. It relates to the recommendation made in the initial report, but the legislative auditor recommends that the Supreme Court of Appeals of West Virginia comply with his recommendations from the April 16, 2018 report concerning its vehicle use and continue with its current course of action to administer its vehicle fleet under the Fleet Management Office of the Department of Administration.
Okay. Thank you. have just a moment to consult. Mr. Robinson, I have just a few additional questions. I'm almost finished here. I would like to go back to Report 1, page 16.
Okay.
And we're back to the taxable income and the personal use of vehicles being taxable income, should have been reported as taxable income. If you could please just, and I believe these are contained, some of these findings are contained on both pages 16 and 17, with respect to the tax implications and how the court had treated other employees with respect to commuting and having vehicles and taxable income.
Based on this report, there was at least one instance where an individual that worked for the court's IT department had been utilizing a court vehicle, and they had in fact had been issued a W-2 reporting that taxable fringe benefit.
Okay. So the court had done it in that instance?
Yes.
Okay. There is also mention, and I believe it is contained as an appendix to this report, about a memo that had previously been authored by a former administrative counsel about the tax implications. Is that correct? Do you recall a memo being prepared or that you saw?
Yes.
And if you recall, just generally, what did that memo actually inform the former administrative director about the use of these state vehicles?
It essentially informed him of the tax implications of using a employer-provided vehicle for commuting purposes or for personal use.
Okay. And just so that our record is clear, I've kind of jumped around. We are still on report number 1 at page 41 of that. If you could please just confirm, is that the memo that to which this report is referring?
That's correct. That is the memo.
Okay. Mr. Robinson, just generally speaking, I know I've asked a lot of questions, just your general understanding and putting these reports together. Let me ask just generally with respect to I understand there were probably many interviews that were done throughout the course of your investigation. Is that accurate?
That's accurate.
Did you participate in some of those? If you can give the committee any idea as to your involvement as to the actual investigation.
I was involved in nearly every interview conducted with court personnel regarding these audits, and my direct involvement with each report was the supervision, planning, and coordination of the efforts of each one of these audits.
Okay. And also, I meant to ask you this question before, and I had neglected to do so. throughout some of these documents and perhaps mentions elsewhere is the name Mr. Denny Rhodes. Could you please tell the committee about Mr. Rhodes' position at the time that this investigation was ongoing and where Mr. Rhodes is now?
Yeah, Mr. Rhodes, Denny Rhodes, was the former is the former director of the Legislative Post Audit Division. Currently, he works for an agency under the Department of Military Affairs and Public Safety.
So was he also involved in the interviews?
Yes, for the most part, I believe so.
Okay. Did you ever, to your knowledge, your recollection, I understand you said with respect to court personnel you sat in on some interviews. Did you ever sit in on any interviews of any current Supreme Court justice?
We met several times with Justice Ketchum regarding his implication in this report.
Other than Justice Ketchum, we're not.
Other than Justice Ketchum, we have met at times with Chief Justice Workman, mostly regarding the exit conference, which we hold to distribute a draft copy of this report and go over the findings contained within with those agency or branch of government personnel. Outside of those two justices mentioned, I did not meet personally, or nor am I aware that our staff did with any of the other justices of the court.
Okay. Mr. Chairman, I don't believe at this time I have any further questions for Mr. Robinson.
Council, we're going to begin, as I indicated, to my left. If you have a question, Delegate Fast, do you have questions? Please proceed.
Thank you, Mr. Chairman. Thank you, Mr. Robinson, for being here. I want to refer to the Exhibit 10 that was on the screen, a memo to Gary Johnson from Joan Mullins, dated February 16, 2018, talks about missing calendars. Did you follow up on that when you received this memo that calendars were missing?
We had actually asked in person for those calendars and went to the court's facilities to try to obtain them. We were actually invited to come there to obtain them, and upon arrival we were informed, much to our surprise, that they were missing. I believe this memo indicates, because the date of that meeting was subsequent to the date of this memo, they were aware they were missing prior to our arrival. However, in terms of following up to as why they were missing, we were given no explanation when we arrived to obtain them, and to my knowledge, there is no explanation for why they were missing.
Did you, as an auditor, inquire further, try to get to the bottom of how documents such as calendars would just vanish?
We asked the individual in charge of the calendars why she believed they may have been missing, to which she did not understand. She said one day they were there, the next they were not.
And what were you hoping to see on these calendars? What information would you expect to be on these calendars?
These calendars were specific to the administrative directors of the court. They were maintained by the court to indicate particular items of business that they attended throughout their years. What we were trying to obtain from the calendars was to substantiate business purposes for the use of court vehicles for Mr. Canterbury that were not available in the reservation law.
And would Mr. Canterbury have had anything, or could he have had anything to do with the disappearance of these calendars?
I couldn't speak to that.
On your second report, page 3, if you could refer to that, please.
Okay.
The language underneath table 1 there, it talks about Justice Davis. It appears that your information tells me that she attended a court function, an anti-truancy event in Wheeling, and then while using a state vehicle proceeded to a fundraising event which would be not court related, correct?
That's correct.
And my question though is, at that time, that was in 2011, correct?
Yes.
Did that violate any policy?
To my knowledge, no. Essentially, the instance of business purpose use coincided with that event. The way she had planned this trip, she left for Charleston to Wheeling, attended the event in Wheeling. Subsequent to the event in Wheeling, she traveled to Parkersburg, where she attended the fundraiser. I believe she stayed overnight in Parkersburg, as indicated in the report. Did not charge lodging to the state. The only other additional charges she charged outside of using the vehicle during this trip instance was meal per diem. And then on the subsequent date after attending the fundraiser, there was an event in Parkersburg that she attended and then traveled back to Charleston. So there was, to our knowledge, no additional costs incurred through this fundraising event.
Well, from Wheeling to Parkersburg, that's a couple of hours at least of driving on a state vehicle, correct?
Yes.
And, but regardless, you're not aware of any policy that she would have violated in attending that fundraising event at the expense of a state vehicle?
No, and the reason we drew that conclusion was that it was coincidental. She could have planned the trip to go to Wheeling and then back to Charleston and then back up to Parkersburg, but she did it in a way that was more like a round trip rather than bouncing back and forth between Charleston. But to my knowledge, no, there is no policy she violated.
Did you calculate any mileage that she would have used the state vehicle for the personal fundraising event?
We did not.
Okay. That would be several hundred miles, wouldn't it?
I'm not specifically aware.
If you're driving a couple of hours. Okay. So no policy violation there. Now I'd like to go to the first report, switch over to Justice Lawfrey. And counsel brought up an important point, I think. Were these, and I'm on page 10 right now, Justice Lawfrey. Okay. Your first report, table 2. Were these rental agreements, unlimited mileage rental agreements, or do you know?
To the best of my knowledge, they were unlimited mileage agreements, yes.
Is that pretty much standard operation for justice when they use a rental car, or any state person to have an unlimited mileage rental agreement?
I can't speak to that specifically, but generally I do believe most rental cars provide unlimited mileage rates.
Okay, and so you're calculating all of these miles. I see there July 19th through 25, 445 miles difference, 390 miles difference, 580 miles difference, 467 miles difference, 171 miles difference, 498 miles difference, and 323 miles difference. You calculated all those miles just based upon odometer readings and differentiated between the mileage from the airport to the hotel, correct?
That's correct.
And how'd you get the odometer readings? Did you contact a rental car company?
On the travel expenses that were submitted and paid by the court for Justice Lawfrey, the rental car receipts indicated the mileage put on the card during the time of the rental.
Okay, but this mileage did not equate to any extra cost to the state because it was unlimited mileage, isn't that correct?
That's correct.
And what would be the difference between Justice Davis then using a vehicle where you said that there was no policy violated, but yet here it appears that you're concluding that Justice Lawfrey violated policy or violated something, and you're actually putting a dollar figure, $2,668.64 on it. So what's the difference?
I think in terms of Justice Lawfrey, the best way I can answer that question is that while the mileage did not attribute to an additional cost, we question the need for the rental car in light of the fact that there may be a cheaper alternative for the means of travel from the airport to the hotel. The number of mileage put on these vehicles during the time he was using them indicates there is significant use potentially for something other than a business purpose. To explain the difference between that and the instance noted for Justice Davis, I would say that if you were to put a dollar amount on the fuel cost associated with Justice Davis's use of that vehicle for those few days, it would be substantially less than the amount for the rental cars used by Justice Lawfrey as noted in our report.
Well, obviously we're looking at seven trips here, out-of-state travel, and compared to Justice Davis, we're just looking at the one trip there. So I would think that would be a little apples and oranges comparison, wouldn't it?
To some degree, yes. I would agree with that statement.
Okay. So this entire Table 2 did not equate to any additional cost to the state. You're just simply looking at mileage and comparing it to what it was between the hotel and the airport?
If you're considering additional mileage or additional cost to be directly attributed to the mileage, no. However, we do take issue with the fact that there may have been a cheaper means for him to obtain transportation from the airport to the hotel. As you noted in the report, the greatest distance between the round trip travel to the airport and the hotel is about 27 miles for San Francisco and the Montreal, Quebec trips. We just feel that it's highly likely that some form of public transportation may have been used that could have been cheaper than the total amounts charged for the rental usage.
When a state official such as a justice of the West Virginia Supreme Court travels out of state, are you suggesting that they should be confined either at the hotel or the airport, subject only to public transportation?
No, but if their confinement, if their lack of desire for confinement relates to potential need to travel for personal reasons during that trip, we potentially feel that that cost should be incurred by the individual seeking to use that type of vehicle for personal use.
Well, if they would normally use a rental car and it's normally an unlimited mileage, I guess why does it matter?
I think it's the role of our office to determine the most cost-effective method for spending tax dollars by state agencies and branches of government, including the Supreme Court of Appeals.
Okay, and so speaking of rules, am I correct, and I was looking on the very first page 7 of your first report, the Supreme Court does not have formal written policies or procedures for the use of vehicles. So, and then I see it looks like in October of 2016 there were some regulations regarding judicial travel that were implemented.
That's correct.
So up until October of 2016, there were no written policies? Is that?
That is our understanding.
Okay. So then October of 2016, that means that 5 of the 7 issues raised in Table 2 would not have violated any written policy, correct?
That's correct.
And in fact, none of the issues on Table 1, if you would flip over to page 7, none of those would have applied to any written policy because there would not have been any written policy during all of those events on Table 1, correct?
As it relates to an internal policy of the Supreme Court of Appeals, that's correct.
Okay. And all of the issues raised in figures 2 and 3, pages 8 and 9, none of those would have violated any written policy of the Supreme Court, correct? Because there were none.
That's correct. There were no policies.
Okay. Now, you touched a little bit on in your report, you talked significantly about W-2s. And I want to be sure I understand. The IRS conducted its own audit, correct?
They did?
Of all of this?
I do not believe the focus of the IRS audit encompassed everything that is encompassed in our report.
Okay. The IRS did, however, focus specifically on the use of commuting, use of state vehicles for commuting, and whether or not there should be any amended W-2s.
Only to which the information that the IRS was provided by the court.
And of course, the IRS, when they do an audit, they can get pretty deep just with their powers. They're not going to be, if they want to get documents, they can get documents, can they not?
They can request documents, but what they're provided by the court is the only basis they have to go on when conducting their audit.
Can't the IRS even subpoena documents if they want to in context of an audit?
I can't answer that question.
Okay. The bottom line, though, is the IRS itself concluded that no amended W-2s were necessary. Is that correct?
That is correct, but I would like to reiterate a fact that is contained in one of our reports. The IRS was not informed of the commuting in a state vehicle by Justice Ketchum by the court, and they were not aware of this use when conducting the audit.
And if I read Justice Workman's responsive letters to some of the inquiries, she pointed out the fact that even after reviewing Justice Ketchum's issues with commuting, that they still concluded no amended W-2s were necessary. Am I reading Justice Workman's letter correctly?
Yes, that's correct.
Okay, so do you have any grounds to dispute that the IRS was wrong in its conclusion that of all the justices, no amended W-2s were necessary based upon commuting?
The IRS's initial ruling did not make any specific indication regarding the justices, and as I pointed out, the information regarding Justice Ketchum's use of a state vehicle was not provided by the IRS when that decision was made. Can you reiterate? There was another part of that question I think I wanted to answer.
Well, I believe Justice Workman she had two responsive letters that I saw. And the first one, she said that the IRS concluded no amended W-2s were necessary. And the second one, she went to painstakingly detail, citing portions of the IRS audit. Wasn't that second letter after the IRS would have then known about Justice Ketchum's issues?
I'm not sure of that, but I am aware of the fact that in regards to providing the IRS information on any justice's vehicle use at the time of the initial audit that began in January of 2018, they did not provide any information concerning vehicle use to the IRS or vehicle use by the justices to the IRS.
Okay, and of course Justice Ketchum insisted on an amended W-2 himself, and he paid some money back, correct?
He did, and that's correct. And it was our stance in this report that it's not so much a retroactive necessity that W-2s should have been issued. Our point, in fact, was that at the time that this commuting was occurring, the court did not treat this properly for tax purposes, and such taxable fringe benefits should have been included on the current year's W-2s issued to each justice.
Okay. So you conclude that the W-2s were wrong for some of the justices because of the commuting issue. The IRS concluded no amended W-2s were necessary, but your point is the IRS didn't have all the information. Is that what you're...
The point that I am trying to make is that at the time of the initial IRS audit, when their decisions were made and finalized, they were not aware of Justice Ketchum's use of a court vehicle for commuting purposes. Outside of that, any other use was specifically related to commuting, and the other instances of court vehicle use by Justice Lawfrey does not relate to commuting instances.
Okay, back to the rental car. We've established, or you've established, that there were no written policies until 2016. October of 2016. We've established that all but 2 of these issues would not have violated any policies because there were none on Table 2, page 10 of your first report. And we've also established that the fact that Justice Lawfrey used a rental car, it was an unlimited mileage rental, and therefore that would not equate to additional money to the state. Now, you couched one of your statements that it did not violate any internal Supreme Court policy. So now I would like to ask, what other policy do you believe would have been violated that is not an internal Supreme Court policy?
The initiation of the October 2016 travel policies was due to the fact that the state auditor's office had indicated to the court that they could not pay out travel expense settlements due to the fact that these regulations weren't filed with the state auditor's office. Subsequent to the submission of these travel policies to the state auditor's office, the court had been being reimbursed for travel expense settlements without a proper filed travel policy with the state auditor's office.
Okay, I'm sorry. Let's go back. What policy, other than an internal written policy of the Supreme Court that didn't exist until October of 2016, what other policy would have applied to all of these infractions that I'm not saying they are infractions, but alleged infractions of Justice Lawfrey other than anything with the Supreme Court?
As mentioned, I mean, aside from the fact that the Supreme Court was required to file travel policies with the state auditor's office and in order to be reimbursed, and again, that's nothing against particularly the court or the state auditor's office. It may have just been an oversight. I can't speak to any particular policy that was violated regarding this rental car use. And again, our point in highlighting these issues in our audit report was to question whether or not this was the most efficient means of travel concerning these instances and the best use of tax dollars.
And doesn't that then place that whole issue on subjective grounds? I mean, if you can't point to a policy, a law, a rule that was violated, then that merely places that whole issue on subjective interpretation.
Possibly so, or we relate it to best business practice. Many other agencies and state government have a policy that governs such instances of travel. The fact that the court did not have one may in of itself be an issue.
And the fact that the court didn't have one, that would have been a fact well before Justice Lawfrey ever entered the West Virginia Supreme Court of Appeals.
I can't answer that question.
Well, are you aware of any rule or policy that existed a year or so before he entered the court?
I can't answer that, not to my knowledge.
Okay.
Delegate Fass, excuse me, Delegate Fass. I'm going to move on, give others a chance to question. We will come around a second time, but in the interest of time,
Thank you,
members
Mr. Chairman.
may wish to answer questions.
Thank you.
Delegate Foster.
My question's regarding Report 1, page 10, the Table 2 that was being discussed, and also on page 5 on Audit Report 2. And my concern is the difference in, for one, on these conferences that were on, was this something that was, meals were provided? And it couldn't be that, could the vehicle have been used for basically lunch or dinner, or were meals provided on this trip, or do you?
I don't have that knowledge.
Okay, and then on Audit Report 2 on page 5, I see Justice Lawfrey's mileage on page 10 and 1, it went anywhere from 6 to 27 miles from round trip to hotel. Mm-hmm. And from Mr. Canterbury, it was 481 miles for Palm Springs, California. What airport was he flying into that there's 481 miles round trip?
I don't have that information directly available, but I could get that for you at some time.
Okay, I was just wondering what the difference was, like this 244, 481, and 212. It would seem that there was a much more economical place to be flying into that was closer to the hotel.
That's quite possible.
Okay. All right, thank you.
Delegate Sabonia.
Chairman, my question is on Exhibit 13, and it's a part of the post-audit meeting summary, March 5th, 2018. In that meeting, Ms. Racer Troy, who happened to be the Director of Division of Financial Management with the Supreme Court of Appeals, was told evidently by Steve Canterbury that of the taxable fringe benefit for Justice Ketchum. And then you drop down to midway part of the page, and it says, Ms. Racer Troy was notified by Mr. Canterbury of the existence of a policy voted on by the justices that would allow them to determine for themselves what constituted business trips in state vehicles and how to report it sometime in August of 2016. Where is that policy? Is that a written policy? It says it was voted on by the justices, but I don't recall seeing a record of that.
And you may not have, it may not be in direct relation to any of the issues in the report, and I apologize, but if that is something you would like to see, I think we could provide that. As mentioned earlier in this, we provided council thousands of pages of documents, and I'm sure that is one of them.
I would like to see a copy of that policy. And then you drop down to the next bullet point. It says, Ms. Racer Troy is uncertain if she made Gary Johnson, I guess who replaced Mr. Canterbury, aware of the taxable fringe benefits associated with the justice's use of state-owned vehicles. And then you drop down, it says the issue of the taxable fringe benefit was not addressed at all with Gary Johnson until the IRS audit. And my question is, who's responsible for ascertaining the taxable fringe benefits for all the justices?
That's an excellent question. It would be our assumption that it would be the Director of the Division of Financial Management of the court.
Okay. If you look at the first post-audit report of April, page 18, it talks about in October 2016, the Supreme Court submitted its travel regulations to the State Auditor's Office, which exempted all justices' travel reimbursements. And it goes on to say, because the State Auditor's Office would not approve court employees' requests for travel reimbursements without an updated set of travel regulations. And these regulations were updated and presented to the court with the justices asked to respond with a vote yes or no by Monday, September 19th, 2016. But then you drop down and it says subsequently in the October 3rd, 2016 administrative conference, these travel regulations were discussed further. I guess no action taken. So my question is, why, if this was demanded back in 2016, you flash forward to 2018, if the State Auditor's Office can not approve of these travel reimbursements, why were they continued to be approved?
The regulations were actually submitted to the State Auditor's Office in October of 2016. I don't have a lot of familiarity with any regulations that were cited by the State Auditor's Office that were outdated, to which they needed to be updated for them to continue to process those reimbursements to court employees. But as of October of 2016, the travel regulations that are referenced in the appendix to this report were submitted and filed with the State Auditor's Office. So subsequent to that date, any travel expense settlements were made through the reimbursed through the State Auditor's Office in accordance with those applicable rules.
So that policy is in place now?
Yes.
Can we receive a copy of that as well?
The travel policy, I believe, is in the appendix of the report, but let me check. Yes, Appendix E of the report reflects those travel policies that were effective October 3rd, 2016, as submitted by the court to the State Auditor's Office.
Okay. And in the post-audit meeting summary referenced earlier, March 5th, 2018, it says that Ms. Racer Troy was aware that a secretary of the court, Connie Toney, was commuting back and forth from work in a state vehicle and awarded special protection of the former court manager. Who would have approved that?
Through our meetings with Ms. Racer Troy, she indicated that that approval was granted from the former Administrative Director, Steve Canterbury.
So is that the only court employee that you found to have preferential treatment?
The specific meeting summary is just regarding the discussion we held that day with Ms. Racer Troy and those other attendees. The nature of the conversation just may have not strayed into those areas, but to my knowledge, when we asked about frequency of court employees commuting in a state vehicle other than the justices, this was mentioned along with the previously mentioned IT individual who was properly issued W-2s to reflect the commuting value.
Thank you. No further questions at this time, Mr. Chairman.
Delegate Summers.
Thank you, Mr. Chairman. Sir, can you help me understand Appendix F of the first post-audit report? It's issued from Administrative Counsel Brandfast to Mr. Canterbury, laying out the legislative rules for state-owned vehicles. Are you there yet?
I am.
Okay. And when I'm reading through that, it's a little bit confusing for me that it states later the applicability to the judiciary of state rules governing the state vehicles, like perhaps these rules don't always apply. And then it says the consequences of improper use of state vehicles are only ethical violation, complaint with the JIC, or determination for untaxed wages. Is that what is that the support of this? If you don't use the vehicles properly, these are the two consequences that happen, and who determined that?
This memo was written by a former administrative counsel for the Supreme Court of Appeals, Kirk Brandfast. Essentially, I believe at this time there were some conversations regarding use of court vehicles by the justices. Obviously, it expressed earlier that Justice Robin Davis had some concerns regarding this and had sent several memos to Arthur Angus, the Director of Court Security, and other individuals of the court, trying to ascertain some facts regarding this use. I think this memo was incepted out of those concerns, and this was essentially their administrative counsel's take on what the proper reporting should be, what the consequences of such use may be.
Okay, thank you.
The process will follow is to go to the second row, left to right, and then we'll come down to the first row on the right side. Delegate Capito.
Hey, thank you. Quickly, who paid for the gas on the rental cars? We see all this mileage. That's got to be a lot of money in gas.
I mean, we are assuming, and that none of them justices are issued a purchasing card to which they could purchase fuel. I would assume that the gas for those trips were purchased by the justices themselves outside of the fuel option that was used.
Right.
So.
Got it. And I mean, I think it's probably safe to say that this would not have been the cheapest option given the mileage to and from the airport, but did you research that, or is that just kind of an assumption? I mean, I wouldn't suggest that it's not a safe one, but is it indeed an assumption?
I would not say to the full degree that it is an assumption. Okay. I think that, several of our staff conducting this audit have common knowledge of the other means of transportation that could be taken from those locations at the airport to the hotels. And we did do some preliminary looking into what it would cost to maybe take an Uber, a super shuttle, et cetera, other means of travel. And comparatively, you're correct in stating that it's probably not the cheapest method to have rented the car.
Okay, and lastly, Mr. Chairman, is it a practice also of Supreme Court justices, or frankly any government worker, to submit for reimbursement mileage that is on a personal vehicle for business purposes?
I couldn't speak to what other agencies.
So none of that was looked into with regard to any, and I'm not going really anywhere, but I'm just curious. So we didn't look into whether there was any business mileage claimed on personal vehicles.
No, we did not.
Okay, so is it, and I don't know if you know the answer, don't answer if you don't know, but is it the practice of the court to take the court's vehicle if a business trip is?
Yes.
Okay.
Yes, and I do believe they are eligible for mileage reimbursement if they do take their personal vehicle on a business-related trip, so long as it is outside of what their what's considered their home or their headquarters, which would be Charleston.
So there's two options for business travel: the court car or the personal car, but you just get reimbursement for the personal car.
That's correct.
Okay. Thanks, Mr. Chairman.
Delegate Harshberger.
Thank you, Mr. Chairman. Thanks for being here today. One question to build on Delegate Capito's question here is, I hear you right that the justices do not have a state-issued P card?
No, they do not.
So you basically use a personal credit card, then submit their expenses back? Or how do they pay?
In regard to...
With the rental cars and their trips, how do they pay for those trips?
I believe that, and forgive me, I can't speak specifically, but in the instances we noted for the former Administrative Director Canterbury, there were times that the court would pay for it up front. There were times, or pay for it directly with their purchasing card or travel card. There were times he would pay for it with his personal credit card and ask for a reimbursement. In doing so, for the former Administrative Director Canterbury, he attempted to prorate business use versus personal use because he was aware that some of the use was personal use. In terms of Justice Lawfrey, it's my knowledge that all of the instances were paid for directly by the court.
Okay, so basically there was no set format for the justices to either use a personal card or Canterbury's card or a P card, purchasing card. It's just kind of what the flavor of the day was.
There was really no policy governing some of these instances.
Okay, and one of the things when on this table 2 on page 10, you have it broke out to the additional mileage, as you quoted over here, for personal use. Mm-hmm. In that, when they submit their expenses or they're approved, was there any additional cost that was hit with the state that could possibly have been for personal use or personal travel, meals or tickets to an event or anything like that?
No, not that we noted.
Okay. And then, was there any additional questioning with the additional mileage, or was it just taken off the receipts and documented? Was it ever questioned, any of the justices ever questioned why there's an additional amount of miles put on these rental cars?
No, there was no question raised by any justices concerning that.
Okay, that's all I have. Thank you, Mr. Chairman.
Delegate Holland.
Thank you, Mr. Chairman. Now, the intent of your audit is for the vehicles is to scrutinize or to dig down into personal use. Would that be a correct statement?
Yes.
Then we go back onto your second post-audit for Justice Davis's trip from Charleston to Wheeling to Parkersburg back to Charleston. Do you find that in your audit that she had charged $115 for meal expenses? That was for the 3 days, is correct?
Mm-hmm.
Do you know what in 2011 what the per diem rate was then?
I do not off the top of my head, sorry.
Okay. And you don't, in here, she had traveled with the Director of Court Security.
That's correct.
And the reason being that she needed the director with her?
Personal security concerns.
Personal security concerns. And what is his salary?
What is whom?
What is his salary at the time? Do you know?
The Director of Court Security, I would not have that answer.
And there's other court security under him, is that correct?
I believe there is a Deputy Director of Court Security to my knowledge, but beyond that, those are the only 2 security officers I'm aware of, but they also administer court security for other instances outside of just for the justices.
Okay. And previously, I believe I read that she only traveled or in the use of the state vehicles only when he was with her, is that correct?
That's correct.
And that was all because of security concerns?
That's correct.
Over from 2011 to 2018? 7-year period?
That's correct.
Did you happen to look at his expenses for that Wheeling-Parkersburg trip?
We did.
But you did not report those. Is there a reason?
We found no issues with them. And as a matter of fact, the inclusion of this information regarding the trip was just because we felt it best to be transparent in noting the fact that she had attended a political fundraiser that also coincided with court business.
But in doing so, then an additional salary was paid while she was attending that political function. So additional expenses were incurred by the state because she had court security while she was attending a political function. So you found no reason to put in there what extra it cost the state for her to attend that.
You indicated an increased salary cost?
No, his salary. If she's attending a political function that's not court business, and she has an additional employee of the court with her, those expenses were not accounted in your post-audit. Did you find a reason why not to include those? If it cost the state, your main focus is to dig down and find reasons why state money was either not accounted for or inappropriately used, but you found that not.
Well, I can't specifically speak to the travel expenses incurred by the Director of Court Security in this instance. I don't have that information available. But as such, it related to two other events related directly to court business to which he would have attended with her regardless of the event, the political fundraiser.
Okay, and follow up on Delegate Fast, his concerns. There's no dollar figure for what it cost for her to attend that with a state vehicle.
Dollar figure for
her to attend that political function using the state vehicle.
No, as we mentioned, it coincided with two other court-related business events, and we did not see that there was any additional cost incurred for traveling from the Wheeling to the Parkersburg location.
Okay, but to follow up on that, and I'll end this with this, Mr. Chairman, but there was, you find no issues with that, but for Justice Laufer, you find issues that I read back in, I can't remember where it was, that reason the mileage might have been put on the rental vehicle because he was vacationing or he had another member of his family or someone traveling with him that could have used the vehicle. You dug deep enough to find that assumption, but you won't dig deep enough to find another assumption of a political event being used or going to in a state vehicle. Is that correct?
I can't speak to assumptions regardless.
Okay. Thank you, Mr. Chairman.
Delegate Zaslow.
Thank you, Mr. Chairman. Just one quick question. I noticed that these cars are 2007, 2009, 2012 years. Were they purchased new?
I don't have that knowledge.
And the reason I'm asking the question, that's not particularly relevant, but the reason I'm asking the question is, did you look at past practice of vehicle usage by the court?
When you mean past practice?
All the way back to 2007, say, or?
Oh, no. Our audit periods were limited to, I think the farthest back we went in reviewing vehicle use was 2011.
So you have no knowledge of historical use of vehicles by the court?
That was outside the scope of our audit.
Okay, thank you.
Delegate Pushkin, I know that you have moved, so I'm expecting that you're not going to try to get two bites at the apple, so to speak. You'll stay there for the rest of the day?
I'll stay here for the rest of the weekend.
Thank you. Go ahead, your question.
Thank you, Mr. Chairman. And I'm looking at Report 1, Issue 1, Mr. Robinson, and thank you for being here too. And so let's go to Table 2 in regards to the rental cars that were supposed to be used during days where there were conferences of official business of the court. So let's just look at Montreal, for example. I'm choosing that one because that was the biggest difference in the miles that were used other than just back and forth from the airport. Because it's been brought up that these were unlimited miles, but there are other issues in regards to time. I know if one were to drive say 65 miles per hour the entire time, it would still take 8 to 9 hours to put that many miles on the car. So what I'm asking is, the dates July 10th through 16th, is that the entire time of the conference, or is that the arrival and departure dates of Justice Lawfrey?
To the best of my knowledge, it would be the arrival and departure dates, which also coincided with the conference, but there is potential for some of the other instances that the length of time that he rented the vehicles extended beyond the length of time of the conferences.
Do we know that, if the length of time that the vehicles rented were extended beyond the length of the time of the conferences?
We would know that, but I would not have that information readily available right this second.
Can we get that? I'd like to see when the dates of the conferences were versus the arrival and departure times of Justice Lawfrey.
So it would be your request that we provide what additional dates beyond the conference dates he remained in those locations?
Okay, because what I'm getting at, if you put that many miles on a car, either somebody else drove the car or you did not intend at least part of the conference, if these dates match up to the conferences. So did we get a copy of the rental agreements?
Yes, our documentation would include the rental agreements, the rental receipts, the total amount paid, the dates the rental car was had, and obviously we have also cross-referenced many of these dates with the actual conferences being held to determine the location of the conferences and the specific dates the conferences were held.
Okay. On the rental agreements, were there any additional drivers listed?
Not to my knowledge.
So there were no additional drivers. So if anyone, at least legally, if anybody drove that car, it would have to have been Justice Lawfrey, correct?
I can't speak definitively to the fact that there weren't additional drivers listed.
But so we don't know if there were any additional drivers listed?
We do not know that.
Okay. Is that something else we could find, if there were any additional drivers listed on the...
I don't know that we would be able to ascertain that information.
Okay. What about the travel from Charleston to, say, the airport in Montreal or to the airport in Monterey? Did the state pay for the flights and the hotel accommodations while attending these functions?
I can't speak to every instance, but I would imagine that if it was not being paid by the conference itself, it was paid for by the state, yes.
Okay, so what I'm getting at is we could have paid for the travel to Montreal, and if these dates match up, well, it would be obvious that one could not have attended the entire conference, maybe not attended any of the conference, while they were putting 580 miles on a rental car.
That's possible.
The state paid for the hotel room and the flight. Would that be a
possible, but
possibility?
I can't be certain of that.
Okay. Let's see, I had a couple more. Well, we go to, let's see, I have it marked here. Issue 2 from, I get report, no. It would be issue 1 and report 2. We were talking about Justice Davis travel to truancy events in Wheeling and Parkersburg. Now, was the fundraiser in question, was that earlier in the day than the event in Parkersburg?
No, I believe it was actually the evening before the event in Parkersburg.
Okay, so it was in between the event in Wheeling and the event in Parkersburg. And I would imagine one would take, in most cases, drive on Interstate 77 to get from Charleston to Wheeling?
That's a common route, yes.
And Parkersburg is also on Interstate 77?
I believe so.
So I guess what you're finding is if you're on your way back from Wheeling, you're going through Parkersburg anyway, instead of driving all the way back from Charleston for a night and then going to Parkersburg. In order to save extra miles and gas, they stayed in Parkersburg, attended another function, and then went to the function in Parkersburg the next day, and then returned to Charleston.
That's correct.
So it would only make sense if you're going. The interstate runs through Parkersburg anyway. That's
why I was previously trying to indicate we didn't really look into this issue further, because we believe, in fact, that there was no additional costs incurred by the state regarding her choice to stay in Parkersburg the evening following the Wheeling event.
Okay. Thank you. Just a brief inquiry with the chair. In report 1, there's also the matter of the Cass Gilbert desk. I assume we're going to be discussing that later.
That'll be the subject of the next inquiry.
Okay, well, thank you very much, and thank you.
Delegate Lane.
Thank you, Mr. Chairman. What authorization exists permitting justices to have dedicated vehicles?
I'm not aware of that. That would be something the court would know internally.
And does the court own these vehicles?
I can't be certain, but it is my assumption.
Okay, thank you. Are there procedures outlining what the Director of Court Security and the deputy are supposed to do?
Not to my knowledge.
I believe you said that the court security consists of 2 people.
Yeah, to my knowledge, yes, there's a Director of Court Security and a Deputy Director of Court Security.
And have any of the other justices asked for court security to drive them to events?
I believe so, but I can't be specific.
Who provides court security to the justices when some of the court security is out on the road driving other justices?
It's an excellent question to which I don't have an answer.
Okay, thank you. On page 7 of the second report, there was an item that said that Justice Benjamin spent $122,457. Could you explain to me what that consisted of?
Various instances of travel, attending various functions related to circuit courts, family courts, and drug courts throughout the state, but in specifics, I can't speak to that.
Did it consist of any overseas travel?
Not to my knowledge.
Okay, thank you. Now, on page 3 of the second report, we were talking about the expenses incurred by Justice Davis. And she went to Wheeling, came back to Parkersburg, spent the night because she had an event the next day.
Roughly, that's correct. She had traveled to Wheeling to attend an anti-truancy event. After subsequently leaving Wheeling, she drove to Parkersburg, where she attended a political fundraiser. But the next day, she had an anti-truancy event scheduled in Parkersburg.
Okay, now, correct me if I am wrong, but don't the state travel procedures provide that one cannot charge per diem expenses unless one spends the night?
That is correct, but in this instance, she did spend the night out, and I guess I see where you're going with this, but I'll let you ask.
So she spent the night at her own expense, but charged per diem to the state?
Yes, she only charged a partial per diem on her first day of travel, and then the full per diem coinciding with the full day of travel the next day.
Okay, so on the day that she didn't charge the state to spend the night, she did charge per diem?
That's correct. Well, meal per diem.
Okay. In your audit, did you determine what the procedure was within the court to okay expenses and okay the expenditures of money? I mean, who all was involved in how these expenditures took place?
As mentioned, the court didn't have any formal policies or procedures regarding how these expenditures were placed regarding travel.
No, I'm talking about expenditures generally. I mean, if someone wanted to spend, let's say, $100,000, what procedures at the court would one have to go through to get that okayed?
I want to try to answer this, but I can't be definitive. But I do believe that expenditures of the court are ultimately approved by the administrative director of the court and potentially reviewed by the director of financial management of the court. But in terms of specifics regarding expenditures, that's a pretty broad category, and I really can't speak to specifics regarding certain expenditure types.
Do the justices exercise any supervision over the director of financial office, or whatever you called him, or the court administrator?
Could you describe supervision?
Well, make sure that the money that is being spent is for a proper purpose according to the budget?
I do not believe that the Supreme Court justices play an active role in the day-to-day operations of the court or the expenditure of the court's budgeted funds.
Okay, thank you.
Delegate Dean, do you have a question or questions?
I want to just thank the chairman for the hearing aid. I can now hear what they're saying.
Okay, good. Delegate Overington.
Thank you, Mr. Chairman. I want to follow up on the questions about the fundraising event in Parkersburg. There obviously was a good bit of cost, especially with security there. Was there any effort to extrapolate the cost dealing with a fundraising effort out of the rest of the expenses that were charged to the state?
When you mean costs associated with the fundraising effort, what particularly do you mean?
With that extra time that was spent there, the security that was required, obviously some additional costs that would have been occurred.
The director of court security traveled with her in this event. It's my knowledge that he is a salaried employee, so he's paid the same rate biweekly that he would be paid regardless of he traveled to that event or not. And the fundraiser was not paid for in any way, shape, or form by the state or the court.
The other question I have deals with the policies that were in place. For the Supreme Court, for the justices, there was sort of vagueness in their expenses. Did other employees working for the Supreme Court have the same vagueness, or were there specific policies that they operated under for their travel expenses?
We didn't review any travel expenses related to employees of the court outside of those listed in our report, which included the Supreme Court justices, one former justice, and the director and former directors of the administrative office of the court. In speaking generally regarding their policies, it did appear within their travel policies submitted to the state auditor's office that justices were granted somewhat special treatment regarding their reimbursement for expenses related to rental cars. And if you allow me to, I'll locate the section of this report that speaks a little more to the justices' travel in general. The initial language that was submitted or discussed by the Supreme Court justices regarding expenses for justices' travel stated that an expense account submitted by a justice of the West Virginia Supreme Court of Appeals shall be honored irrespective of any of the language in these travel regulations. Prior to that being approved, it was amended at the request of, I believe, Chief Justice Workman to include that an expense account submitted by a justice of the Supreme Court of Appeals pursuant to judicial branch policies shall be honored irrespective of any language in its travel regulations submitted to the state auditor's office. This particular policy is different than the policy that governs the travel for typical court employees.
Are the court's policies different from other branches of government's travel expense policies?
I can't answer that. We did no direct comparison between their policies in comparison to other agencies.
So after 2016, was there still a difference between the policies of court employees versus Supreme Court justices?
I do believe that in the October 2016 filed policy, it did make the statement regarding rental car expenses being different for justices. And obviously, Section 10.4 of these travel regulations specifically address justices' travel, which would indicate some differentiation between the policy that applied to the court employees. So I believe my answer to you would be yes.
For the policing of those policies, was there a different standard for the justices versus the court employees?
In terms of the policing of those policies, which would have been done internally by the court, I can't speak to that.
Thank you, Mr. Chairman.
Delegate Lovejoy.
Mr. Chairman, thank you.
There you go.
Just a few questions for you. Thank you for coming in today. I want to ask you, with regard to the correspondence that we've talked about today in the initial exhibits, did you find any justice prior to Justice Davis that was writing for the need of a policy? I think she did in 2016.
I mean, concerns were expressed by various justices regarding various matters in administrative conference minutes, in particular regard to travel, vehicle use. I think primarily concerns were expressed initially by Justice Davis, but that's not, I can't speak to the involvement of the other justices and their concerns.
But as I see, there's no written call to action by anyone prior to Justice Davis in the exhibits we've been provided, correct?
I don't have all, as noted, there were thousands of documents that we were made available that aren't all directly related to the findings in our reports. I can't speak to whether or not that's the case.
Okay. I think we've established that, at least with regard to 2011, we had no written policy at the court with regard to the use of the court vehicles, right? And I'm specifically trying to focus in on this trip in 2011, as I understood with Justice Davis, and I understand you to say there was no cost to the state additional. Is that correct?
It's our stance that the way that the trip was planned and coordinated, that there was no additional cost to the state. No. Court security is a salaried employee. There was no specific additional cost. I can't speak to the specifics of whether or not he received any expense reimbursements, such as per diem for that instance. It's likely, but I can't speak to that definitively. But in terms of the fact that she was attending both events, he would have attended with her either way, and it's likely that a per diem would have been paid. However, given the fact that there was an overnight trip, the per diem rate may have been higher, because that allows you to claim the full per diem rate because it's not a travel day.
And am I correct that as in the course of your investigation, and yours being the auditor's office, you came to learn that there had in fact been threats against the body and indeed the life of Justice Davis?
That's correct.
And you were also provided with some information that included a report called Murdered Justice, which discussed a history of attacks on our judiciary across the country?
That's correct.
And that report that was provided showed that since 2008, there's been an unprecedented number of attacks on the bodies and lives of our judicial officers?
I don't recall the specifics of that report, but if that what was mentioned, I'll take your word for it.
Okay. I have no other questions. Thank you.
Okay.
Delegate Fluharty.
Thank you, Mr. Chairman. Briefly, thank you for being here, sir. Now, this infamous trip by Justice Davis that we've been talking about ad nauseum, there were 2 nights of stays, right, overnight? It was a 3-day trip, but 2 nights were overnight stays. Correct me if I'm wrong.
Just give me one moment to confirm that. I believe you may be correct. I can read the summary of the report and how we written it. If
sure, but I just want to clarify here that I believe there were 2 nights that she stayed overnight, and in the auditor's report, says that she charged no lodging for those 2 nights, correct?
Yeah, that's correct, and you are correct in assuming that there were 2 nights. Yes, she did travel to Wheeling at the subsequent close of business here at the Capitol, stayed in Wheeling, attended a truancy event that morning in Wheeling, traveled to Parkersburg, stayed in Parkersburg, then traveled back to Charleston. But yes, there was no lodging charge to the state.
3 days, 2 nights, no lodging charges. It would have been perfectly permissible for her to charge lodging for those 2 nights, right?
I would question whether or not it would be permissible if the reason for her needing to stay was to attend the political fundraiser, but outside of that, I would agree with you.
Well, there were 2 events during that 3-day course that were directly related to the anti-truancy events, right? So obviously, at least one of those nights,
yes, absolutely
permissible.
And it is possible that it would be permissible on the second night if the pure intent was to make it more convenient to travel from Wheeling to Parkersburg rather than back to Charleston, then back to Parkersburg the subsequent day.
So at a minimum, she could have charged at least 1 night of lodging to the state, which she did not do, right?
That's correct.
So by not doing that, she saved the state some money in that area.
You could say so, yes.
Very briefly on the Law Free conferences, I just had a document in front of me that had the names. I think it's gone now, but did you check any of the agendas from those conferences to see if he actually attended?
No, we did not.
Do you know if he was on any panels that may have happened at those conferences?
I can't speak to that now. We did have some difficulty determining specific locations of these conferences and reaching out to the organizations that held them. We were able to ascertain the specific locations to confirm whether or not that the hotel he resided in during these trips was the same location of the conference or not. But beyond that, in terms of the agenda or specifics of what occurred during the conferences, I do not have that knowledge.
And did he ever provide justification for the increased travel after arriving at a conference and then taking off for hundreds of miles?
Not to us.
And one last question. The reservation chart, we talked about destination being omitted from many of these requests.
Mm-hmm.
There's no written policy, right?
That's correct.
So there's no written policy that requires destination be part of it?
No, but in terms of the IRS regulations, if an employee, including a justice of the court as an elected official, is provided an employer-provided vehicle, it's the employer's duty to track business versus personal use miles so that those miles can properly be applied for personal use instances to the employee's W-2s if it is considered a taxable fringe benefit.
Sure, and that's the individual and the tax implications involved therein, but I'm asking about the specific policy by the Supreme Court. There's no policy that currently exists. Now, as to that, are these forms when you go to fill it out, this reservation chart?
The reservation log, it's my understanding from what we've reviewed that it's more of an online system. Oftentimes, I believe the procedure was that if a justice was seeking to utilize a court vehicle, they would notify the court security who administered the system and also administered those vehicles, and would notify them of the dates that they would need the vehicles, and if they wish to provide a business purpose, they would.
Okay, so who actually fills it out?
I don't have that information. I would assume it's most likely the Director of Court Security upon receiving the request, but there is likelihood that the justices or the Administrative Director of the court may have access to that system in order to do so.
So and related to that, now we don't even know who actually fills it out, but the form itself, if it's online, paper format, however, does it have a section for destination to be filled out? It does. So when you reviewed these forms, although we don't know who actually filled them out, when you reviewed them, you were able to see that their areas were left blank with a form destination. Okay, that's all I have. Thank you.
Delegate Byrd.
Thank you, Mr. Chairman. Thank you again for being here and the work you put in on this. To follow up on Delegate Fluharty's question about the conferences, was there any check by the legislative auditor into whether Justice Lawfrey turned in CLE credits for any of these conferences?
No.
Okay. I'd like to, can we pull up on the screen Exhibit 1?
Certainly.
And following up on Delegate Fluharty's question, it appears to me that it looks like line 3 that a copy of this form that Delegate Fluharty and you all were discussing about should have been attached to this memo. We don't have that. Have you seen it?
It's possible. Again, we reviewed thousands of documents. I can't speak to that.
Fair enough. And I would just ask, Mr. Chairman, with leave of the committee and you, if we do discover that, if we could maybe attach that as 1A, Exhibit 1A.
Certainly.
Thank you. Talking about the intranet, was there a time frame provided to you of how long that was available? Was it like between 2012 and 2017?
We may have that information, but I can't speak to it at this moment.
And just provide that if you can. I'd like to turn your reference now over to page 9 of the first report.
I'm there.
Okay. Talking about, it's right, the legislative order was provided a memo written by both the director and deputy director of the Supreme Court Security. Were there any other individuals that were involved or may have been involved in filling out these forms if the justices didn't during the time period of 2012 to 2016?
Not to my knowledge.
Okay. And last question is on page 12 of the same report. I see here where we've included a response from Justice Lawfrey, and it talks about his response to a draft audit report. And what we have is the final, correct? Is there any way that we could look at, or were there many changes between the draft and the final?
There should not be. The draft of our audit reports are simply noted as draft until they're formally released to the post-audit subcommittee.
Okay, did you receive a response from Justice Lawfrey when the final one was completed?
No, the response that we had requested in the draft that had been provided was content-wise the exact same as the final product. The only changes that would have occurred would have been minor punctuational formatting or grammatical errors that we caught prior to sending this to print, but the content of the draft report provided to Justice Lawfrey, to which he responded to, contained everything that the final draft that you're reading from today does have.
All right, and one final question is we've heard a lot of questions about meal expenses, hotel expenses. If those expenses are incurred by a justice and turned in to be paid as an expenditure for any of these trips, who are those receipts turned into?
I'm not sure. I would speculate that it would be the director of court financial management, but I'm uncertain.
And who do they turn those over to? Do you know? To be paid?
To be paid, the state auditor is essentially the person that approves these reimbursements for repayment to any individual submitting a request for reimbursement.
So would you recommend us talking to the state auditor about where these receipts possibly could be stored or the Supreme Court?
Are you referencing receipts regarding these travel instances?
If any receipts were turned in any of these travel instances?
If anything was paid for by the state, it's highly likely that the the state auditor's office would have record of that.
All right, thank you. That's all I have.
Let me just inquire due to the time. I'm assuming most of you in the back row there will have questions. Am I correct on that? All right. Why don't we break for lunch? I'd hope we'd get through this first series, but it's obvious we're going to go beyond 1 o'clock. So let's break for lunch. It's now, let's break for 45 minutes. We'll be back here at 1:30, and we'll begin with Delegate Meller's questions. We're in recess till 1:30. Yes.